Okay, afternoon, everyone. My name's Helen DL, and I'm the Director of Public Policy for the IUA. Welcome, and thanks everyone for your attendance at today's market briefing on biometric, pixels, and tracking technology lawsuits. A major uptick in US privacy litigation filings over the last few years have caused concern for insurers and policyholders alike. From biometrics to Metapixel, plaintiffs filing these privacy class actions leverage old laws to address new data collection practices, disclosures, and technologies, and have seen general success. These types of cases have been the subject of much discussion at IUA committee meetings, from a data protection to cyber insurance perspective, and more generally in respect of liability. There will be an opportunity to ask questions online via the Q&A facility, and the speakers will answer any questions in the time allotted. In addition, this session is being recorded and will be available on the IUA's YouTube, and we will circulate a link to the recording after the event. So without further ado, I would like to introduce you to our speakers from Clark Hill PLC. Myra Jaworski represents clients in defence of data breach class actions, privacy torts and statutory claims, pixel tracking and commercial surveillance matters, internet defamation, technology disputes, and cyber subrogation and media liability claims. Mariah defends clients in response to regulatory inquiries and investigations arising out of data incidents and privacy practices, including before State Attorney General offices, the Federal Trade Commission, and the Department of Human and Health Services, Office of Civil Rights. Mariah litigates in many states and federal jurisdictions throughout the United States. Our other presenter is Melissa Ventrone. She leads Clark Hill's cybersecurity, data protection, and privacy business practice, where she directs her skilled multidisciplinary team of first responders to minimize security risks, ensure regulatory compliance, and curtail damage in the event of a data incident. Melissa reviews data security policies, procedures, and incident response plans, and works with clients to create a tactical action plan to establish compliance with state, federal, and international laws and regulations and minimize cyber risks. When a damaging data breach or cybersecurity attack occurs, Melissa and her team are available 24/7 to manage the end-to-end process from containment to recovery, minimizing operational disruption, negative repercussions, and costs. Melissa has managed thousands of data security incidents across all industries, ranging from lost devices at small companies to high-profile cyber attacks impacting millions of customers' data. So, Mariah and Melissa, over to you.
Thank you, Helen, very much for that lovely introduction. And we really appreciate the opportunity the IUA has provided for us to go ahead and present on some topics that are very near and dear to our heart. I'm going to share my screen real quick. So as Helen said, we're going to be talking about cookies and pixels, biometrics, AI, privacy, litigation trends that we're seeing in 2023. I won't go through the introduction since Helen just did a fantastic job. Just a little background on Clark Hill. We are a full service law firm. We have 27 offices ranging from coast to coast in Ireland and Mexico City as well. We also offer non-legal services too, from data mining to data extraction, data compliance, lobbying, regulatory consulting, etc. So a very broad, well-rounded, full-service law firm. We're going to talk about today, we have a bunch of different topics, obviously. We are going to go into Pixel and Spyware litigation. We'll talk about the things that we're seeing from the biometric perspective with biometric updates. We'll touch on AI, which is obviously the new frontier, and some thoughts about underwriting to these risks. With that, I will turn it over to Mariah.
Thanks, Melissa. Good afternoon, everyone. So before we jump into what we're seeing on the privacy litigation front, let's just level set and talk very briefly about the types of tracking technologies at issue. What are these technologies? Fundamentally, tracking technologies are different types of code or script that facilitate communications between a visitor to a website and the website itself. There's different purposes behind these technologies. So for example, we have session recorders up on the screen, cookies and pixels. They all have different purposes and they collect different types of information. Cookies, for example, first-party cookies or essential cookies are used by websites themselves to recognize visitors to the website or to maintain different items in a shopping cart. But there might also be the use of third-party or tracking cookies, and those are cookies by other companies. So those are sort of advertising companies, potentially Google Analytics, et cetera, that are embedding code onto a website browser and following that website user around the internet, largely for purposes of displaying personalized advertisements to them. Similarly, session recorders are used by businesses to understand how visitors interact with their websites, to sort of analytically evaluate the performance of their website. Where are users spending their time? What are they clicking on, et cetera? And that information is relayed back to the website owner and operator and used for purposes of performance metrics. Similarly, pixels, they're a type of HTML imagery really that are used for purposes of understanding whether users are, for example, reading emails, again, how they're interacting with websites. Pixels can be used for cross-device tracking. So different purposes and different functionalities behind these tracking technologies, but fundamentally what's going on here is these are third-party technologies that are being embedded onto either browsers or onto websites and sharing information about a website visitor with the third party. So there's two real takeaways here when we talk about tracking technologies. The first is that these are very common. These are like the backbone to the advertising online ecosystem. Many website operators, many e-commerce companies, many healthcare companies, you name it, they're utilizing tracking technologies for their own purposes and for purposes of running and analyzing advertising campaigns. And the second main takeaway is that historically, tracking technologies were really the domain of marketing departments, right? These were where website developers, maybe your in-house digital marketing folks, maybe your outside digital marketing folks, they were the ones involved in running these campaigns and deploying these technologies on websites. And there wasn't really an awareness historically that there was any legal or reputational risks associated with that until very recently. So next slide, please. All right, so what has happened in the last few years? Historically in the United States, as Helen mentioned, we have these old laws that plaintiffs' counsels have now started to leverage in new and novel ways. And those laws include our federal wiretapping law, and in different jurisdictions, so in California, in Florida, in Pennsylvania, for example, we have state wiretapping laws that have certain very specific requirements around what's known as two-party consent. So both parties to the communication need to consent to that communication being recorded. In the late 1990s and early 2000s, we saw plaintiffs' counsels leverage these state and federal laws to bring large class action lawsuits against customer service call centers, right? I mean, think about that. Historically, it makes sense. These are phone calls that are being recorded, and the plaintiffs' counsel and the plaintiffs' bar was very successful. It led both to the development of what we call whispers, or those "you are being recorded" disclaimers at the outset, but it also led to some very large class action settlements at that time. And skip forward another 10 years, we see the plaintiff's bar really scale up, right? If you think about the volume of calls in call center, that's quite large, but think about the volume of daily interactions with websites. So they're harnessing these wiretapping laws and they're applying them in the context of that session replay technology. Essentially, the argument is when you are communicating with a website, the session replay vendor is intercepting your communication without the proper authorization. And these state laws have two critical, important pieces to them. They have what are known as statutory damages. So that's up to $1,000 or even $5,000 per violation. And they have private rights of action. Those are the two sort of components of a formula that make for a very good class action complaint. So we saw an uptick in the 2017-2018 era around session replay technologies. And at the time, they were largely rejected by the trial courts in the United States. So the trial courts were holding either that the communication between the website visitor and the website itself wasn't really a communication as understood under these laws. They were finding at early stages of the litigation that certain defenses applied. So they were, for example, holding that there was implied consent by users on a motion to dismiss or a motion for summary judgment, or that the technology itself or the website operator was a party. So a lot of these defenses to wiretapping claims were being endorsed by trial courts during this era. But then in 2022, 3 different things happened that really laid the foundation for this large uptick in wiretapping and privacy litigation. The first is that at the circuit court level, so that's the Court of Appeals, the Federal Court of Appeals that sits between our trial courts and our US Supreme Court, we had 2 major decisions essentially reversing those trial court decisions and saying, not so fast. We think there's something here. There's something to these wiretapping claims. We're going to send it back down to the trial courts and make them dig into the facts and investigate, these defenses of implied consent, investigate whether these are really 2-party communications, et cetera. So that's up on the screen is the 9th Circuit and 3rd Circuit decisions, Javier versus Assurance and Papa versus Harriet Carter Gifts. So on the first sort of change was that we got these reversals at the circuit court level. Then in June 2022, so about a year ago today, there was this big article by an investigative online newspaper known as The Markup that essentially discovered that 33 of the top 100 hospital systems in the United States were deploying Metapixel technologies on their websites. And specifically, not just on their websites, like on the front page, but in the patient portal. And this article led to just a general and increased awareness that healthcare entities were sharing information, arguably personal health information, or at least sensitive personal information, with Facebook, Meta. And the allegations there were that Facebook Meta was then using that information to serve targeted advertisements to the individuals who went to these healthcare websites for purposes of potentially diagnosis, for purposes of pharmacology, servicing ads pertaining to medicines and prescriptions, et cetera. So after the Markup article was released, we saw an immediate uptick of about 100 lawsuits being filed against some of the most sort of well-known name brand health facilities and health systems in the United States. Also at this time in the US, we had the Dobbs decision from the United States Supreme Court. That was the Supreme Court's reversal of Roe v. Wade pertaining to abortion rights in the United States. And what really came out of that was, again, this increased awareness that there is a lot of sensitivity to certain types of online information, including information pertaining to reproductive health rights and reproductive healthcare searches. So, for example, there was an immediate risk in the United States that online searches pertaining to abortion services, for example, might be disclosed to law enforcement in different states that had moved to ban or criminalize abortion. So we saw our healthcare regulators immediately come out and say, we are aware of this issue. Here's what organizations should be doing with respect to online health identifiers. We want to protect it, but more importantly, we consider it PHI. We consider it regulated information, even though it's things like IP address, device ID, et cetera. So those 3 factors really led to this increased awareness around online tracking, particularly of certain types of more sensitive health information. Next slide, please. All right, so what are we seeing with this rise in spyware claims? Again, the most common allegations are that the use of these technologies is intercepting a data communication between a visitor to a website and the website itself. And the interception is occurring because a lot of these technologies are third-party vendor technologies, essentially. And that is the interception of a communication. Oftentimes in these lawsuits, the businesses are being sued under an aiding and abetting theory. So they're not sued directly for the interception, but they're sued for aiding and abetting their vendor's interception of a communication. We also see, of course, a lot of lawsuits brought particularly against chatbots and virtual assistants for the chatbot feature, where there's not those disclosures regarding the use of the third-party chatbot vendor for purposes of facilitating the communication. And those chatbot cases tend to be a little bit more straightforward, right? There's actually a sort of written or content of a communication occurring in the chatbot context. Whereas in the pixel cookie session replay, the communication is really just the sort of disclosure of information pertaining to my use of the website. There, as mentioned before, we are seeing plaintiffs bringing claims under these long-standing existing statutes at both the federal and state level. An example of this is going to be an uptick in the Video Privacy Protection Act claims. The VPPA is a statute that was enacted in the 1980s for one very specific purpose, relating to the sharing of video subscription lists, but now being leveraged and utilized against companies that have videos on their website, so recorded videos on their website, that are sharing information around user browsing activities with third parties. So again, the VPPA is a common statute that we're seeing leveraged in some of these contexts to the extent it might apply because the website operator has a video or some kind of recording on its website. As mentioned, obviously the federal wiretapping statute is a big one, but also the three main states at play here are California, Pennsylvania, and Florida. Again, because those states have their own two-party consent statutes that have that statutory damage and private right of action component. We're also seeing just the creativity never ends. Very recently, we've seen lawsuits where plaintiffs' counsel have identified other state statutes that protect or require businesses to hold confidential certain types of information. So for example, Pennsylvania, we saw a recent tracking technology lawsuit against a large retailer of hunting and outdoor supplies under that state's Uniform Firearms Act. Many people didn't even know that law really existed until this lawsuit was brought, but the idea was the Firearms Act requires businesses to keep confidential information about gun purchases. And because there was tracking technologies on this outdoor retailer's website, information pertaining to a gun purchase was shared with an advertiser, and that's in violation of the Uniform Firearms Act. So the real takeaway here, if you will, is just the scope is ever expanding, and there is definitely attention being paid by the plaintiff's bar to identifying existing state laws for purposes of leveraging them in new and creative ways to bring these types of tracking lawsuits. We also see what's known as common law claims. So those are just claims that arise through our case law, through decisions of our judiciary. And the common claims that are brought are invasion of privacy, unjust enrichment, breach of either implied or express contract, where the contract is the business's privacy policy and its terms of use. So plaintiffs have had some mixed success in those types of claims. There are defenses to these lawsuits. They include implied and actual consent. So one of the emerging themes that you'll see throughout this presentation is the importance of consent banners, some form of consent recording and mechanisms, and then the importance of, auditing your privacy policy and making sure that what you say as a business or an insured in your privacy policy is actually accurate with your practices. And the enforceability of privacy policies as a means of demonstrating that the user has consented to the terms. So certainly consent is a big emerging issue. And then there's going to be statutory specific defenses. So if we're faced with a VPPA case, we're going to be looking very closely at whether or not the insured is really a video service provider, right? There are strict and narrow statutory definitions that can provide the basis for a legal defense. However, unfortunately, they're not always resolved at that early motion to dismiss phase. And a lot of these cases have been proceeding to discovery, to class certification, et cetera. Next slide. All right. Another thing to just flag for the audience is that the plaintiff's bar has been very clear. Because of the work that we do in this space, and also because of just some of the other activities, we have a relatively good working relationship with some plaintiffs' attorneys on the other side. And they've been very clear to indicate where they're going with this privacy litigation filings. I think the next wave in the next 6 months to 18 months is definitely going to be around leveraging existing state UDAP laws and unfair competition laws. So every state in the United States has some equivalent of an unfair competition law or a deceptive acts and practices law. So this is not going to be specific to any jurisdiction. This could be cases that are brought in every jurisdiction throughout the United States. And those state laws also tend to have private rights of action and statutory damages. And plaintiffs are going to leverage those existing UCL laws for purposes of bringing complaints against businesses for their cookie management practices. So where are they really focused? They're focused on the idea of testing consent mechanisms and determining whether the representations that businesses make in their privacy policies are accurate. I have been told by plaintiffs' counsel that they have this belief that businesses are not honoring global privacy controls, that they're not honoring do not track signals that visitors are sending via their browsers, telling websites, don't track me, don't drop third-party cookies on me. There's this feeling that when you opt out of advertising cookies or tracking cookies, that businesses are not honoring those opt-outs. And that's going to be the next focus of a new kind of wave or subwave, if you will, of these privacy litigations.
So in addition to the litigation that we're seeing out there, obviously the FTC has been active in this space as well. And I think one of the most publicized actions was the one against GoodRx Holding. The interesting thing about this one is it's the FTC's first enforcement action under the healthcare notification rule, which has been out there for years. The healthcare notification rule for the FTC essentially says that if you're a vendor that uses PHI or other related entities, and you're not covered by HIPAA, if there's a breach of information, you're still required to notify individuals, FTC, et cetera. And so here, with GoodRx, they were failing to notify customers about the unauthorized disclosure of their information. They were collecting information online through the website and then sharing it with other third parties, which is the unauthorized disclosure, if you will, to Facebook and Google, and also providing an access key that provided full administrative privileges. What the FTC said is GoodRx promised its users that it wouldn't share personal health information with advertisers or other third parties, and they repeatedly violated this promise and continued to share the information with Facebook and others. And so that was a violation of the FTC's Section 5, which prohibits unfair and deceptive trade practices. And then in addition, they took the information that they collected in addition to sharing it, and then they used it to target the various visitors with various advertisements. And so they were monetizing the information that they were collecting, and there wasn't any process in place for the destruction of this information. The proposed order required GoodRx to pay $1.5 million settlement, and they're prohibited from sharing user data with third parties. Interestingly enough, that settlement in the scheme of things is relatively small, especially when you look at BetterHelp, Inc., which is a proposed $7.8 million settlement to refund, if you will, or pay to consumers associated with their wrongful practices. So on March 2nd, which was pretty recent, the FTC announced a consent decree with BetterHelp for, again, unfair and deceptive trade practices when they were making the information available to others. Now, BetterHelp offers a variety of different services. They offer counseling to minors, the LGBTQ population. The order also said that BetterHelp wasn't certain which entities or which counselors that were providing these services were covered under HIPAA and which ones weren't covered under HIPAA. And they had a seal on their website that said that they were HIPAA compliant. And the FTC noted that they didn't have any third party that came in and reviewed any of their HIPAA compliance. And so that was a deceptive practice as well. They also, BetterHelp, just like GoodRx, also use its own data for marketing purposes, including research and product development. The proposed order requires BetterHelp to get express affirmative consent for future disclosure of protected information, which is defined to include IP addresses and cookie IDs with third parties. So we do see the FTC becoming extremely aggressive in this space as well.
All right, so we have the plaintiffs bar obviously paying attention to this idea of impermissible disclosures of online information, right? And we see it with the regulators, with the FTC getting involved. And of course, in California, where I'm located, we have our own California Consumer Privacy Agency, and obviously the first of its kind State Privacy Act. And very recently, over the summer, we had the California Attorney General's first consent order against a business for a violation of a CCPA and CPRA dictate, but it concerned those unauthorized, sort of impermissible disclosures. So this is the California Attorney General's enforcement action against Sephora, a major beauty retailer, international beauty retailer. And what did this consent order concern? Fundamentally, what the Attorney General said here is, if you as a business do not have contracts in place with third parties, including the third-party advertisers, who you allow to embed various tracking technologies onto your website, then we're going to consider that disclosure to be a sale. And under California law, a sale of personal information requires that you offer consumers certain rights, the right to opt out of a sale. It requires that you have a very prominent do not sell hyperlink on your website, etc. Things that did not exist and that Sephora was not doing here. So this decision really, or this order, really clarified that in the eyes of the regulators, these disclosures really constitute the sale of personal information, and users, visitors, should be able to opt out of the sale of their information in that way. Sephora also did not honor global privacy signals. So let's jump back for a minute. What is a GPC or a GPS? These are signals that can be set by users or visitors to websites at the browser level. These signals communicate to websites that you do not want to be tracked. You do not want third-party cookies, targeting cookies, advertising cookies, etc., to be dropped on your browser. And businesses in California, but also nationally, need to start ensuring that they have the processes in place to honor these GPC signals. And the reason for that is because many regulators throughout the United States, particularly in those 10 states where we now have enacted privacy laws, are really looking to allow consumers and visitors to leverage these tools and these online kind of technologies to communicate their preferences around tracking to businesses. So Sephora did not honor those global opt-out signals, and that was another basis for the violation findings in the consent order. So ultimately, it was a $1.2 million civil penalty issued against Sephora. And the Attorney General at the same time also indicated their various enforcement priorities for 2023, which included an investigation that is still ongoing against mobile apps. Again, for the opt-out of the sale of data. So the importance of allowing consumers rights over how businesses collect and use their information is critical when we think about federal and state regulators. One last thing I want to mention here is that in December of 2022, we had a bulletin, or essentially guidance, from our Federal Health and Human Services Office of Civil Rights. And HHS clarified, as we've now seen the FTC do, that online identifiers such as IP addresses, device IDs, et cetera, constitute personal health information that needs to be subject to a contract. So if you are a healthcare organization and you're leveraging or contracting with a digital marketing company, you need to have a business associate agreement in place between you and that marketing company, between you and that online advertising company, governing the the collection and safeguarding of that information. And if you don't, HHS will consider that an unauthorized disclosure, an impermissible disclosure. So that was a bulletin December 1st of 2022. All right, so a lot of activity in the Pixel online tracking space, as mentioned, but now let's move over into BIPA. I mean, the real concern here, I think, when we think about pixels is we don't want pixels to be the next BIPA, right? Because what we've seen from a business perspective is that BIPA has just been catastrophic. Some of the recent decisions that we'll talk about have really made operating in the state of Illinois very challenging for businesses that are utilizing biometric technologies, et cetera. But again, quick level setting, what is BIPA? BIPA is the Illinois Biometric Privacy Act, excuse me. And fundamentally, it's a law that regulates how organizations or businesses that operate in the state of Illinois can collect biometric information. In order to do so, they need to have certain steps in place. The first is that they need to obtain, in advance of collection, a written release from the individuals from whom they're collecting the biometric data. So this cannot be a retroactive release. We've seen businesses try that and it hasn't worked. It's been rejected by courts. So this release needs to be in advance and it needs to be express and written, right? So there's always going to be challenges if we're doing virtual try-ons, if we're doing kind of the online collection of biometrics, it's going to be challenging to know whether an opt-in or some kind of affirmative online consent constitutes a written release under BIPA. Additionally, organizations have to have written retention and destruction policies in place that govern how long they retain this biometric information. They need to disclose to individuals, employees, et cetera, how they're going to use this information, if they're going to be sharing it with other third parties, and they're restricted from selling it. So at a very high level, and at a very high level, these are kind of the main component parts of BIPA, but a lot of the litigation, as you may imagine, has focused really on that written release and the idea that biometrics are being collected without consent. All right, so the end of 2022 into 2023 has really been a blockbuster year in the BIPA litigation space. At the end of last year, we had our first BIPA trial, and that was Rogers versus Burlington Northern Railway Company. What do you need to know about that trial? Here, one interesting thing is that the jury only deliberated for 1 hour. So both sides had put on sort of robust defenses. I think Burlington Northern had tried, as many defendants do, to challenge whether the technology at issue was really collecting biometrics or whether it was immediately converting it into stored identifiers. That's one of an emerging kind of defensive theme that we've seen that was not picked up on by the jury at all or adhered to. So fundamentally, there was a finding that Burlington Northern collected biometric information of its employees at this rail yard. And the judge ultimately determined to issue a damages award in the amount of $228 million. Importantly, the judge in that case looked at the class size. It was about a 50,000 person class. These were all current and former employees of Burlington Northern at a certain rail yard. Excuse me. And he applied a one-time statutory damage amount of $5,000. So every class plaintiff was entitled to $5,000 in damages, and that's how he calculated the ultimate damages award here of $228. And that's an important formula because Burlington Northern decision is now being challenged following the White Castle Supreme Court decision. So after we had that big verdict, we got two decisions from the Illinois Supreme Court that really have just worked to majorly expand the scope of potential liability under BIPA. The first is going to be Timms versus Black Horse Carriers. What you need to know about this case is that for the last sort of 10 years of BIPA litigation, there's been a lot of dispute over the relevant statutory period. So for example, how far back can plaintiffs look, right? Plaintiffs have always taken the position that it's a 5-year statute of limitations. They can go back 5 years and look at all the scans. And the defense bar has said it's a 1-year statute of limitations. And finally, we have the Illinois Supreme Court clarify that it's a 5-year SOL that applies. So the broadest and the biggest sort of statutory period is going to be relevant to the BIPA calculation. And then in February, we had the White Castle decision. In this decision, the Illinois Supreme Court essentially says, we get it. This is harsh. This is an absurd result. This essentially, though, is unavoidable because we consider that the statutory language of BIPA is so clear, and we need to determine whether a BIPA violation is sort of a one-time violation for every plaintiff, for every class member, or whether every individual scan is an accrual or is a violation of the act. And the Illinois Supreme Court, in a close decision, but but ultimately ended up determining that every independent scan of a biometric fingerprint, for example, in the context of employee access to a workspace, constitutes a violation of the law. So what does that do? Now we have the 5-year statute of limitation under Black Horse Carriers, and then we have multiple violations for every class plaintiff. If you are a biometric defendant in the context of an employer-employee relationship, sometimes biometrics were used for access control and timekeeping purposes. You're scanning up to 3 times a day. You're scanning in, you're scanning out at lunch, you're scanning out at the end of the day. So this decision really extrapolated and expanded the scope of potential damages available to plaintiffs under BIPA to an extraordinary amount. In the White Castle decision, White Castle itself had estimated that it could potentially be on the hook for $17 billion in damages. And the court said, again, it's absurd. It's certainly harsh, but we are governed by the language of the statute, and we feel essentially that the statute is clear and we have no choice. So a few things to know. The first is that White Castle has obviously sought essentially reconsideration of the decision before the Illinois Supreme Court. So what they're essentially asking the Supreme Court to do is take a closer look at its decision and amend the order. And they're looking to do that on a few different bases. The first basis is that, again, they're going back to this technology and the idea that the technology was really only collecting biometrics one time. That was the initial time. And that all subsequent scans were really just a conversion of essentially code associated with an individual. So a very technical argument. The Supreme Court did not pick it up on the first round. White Castle is asking them to reconsider that. We saw a similar argument brought by Burlington Northern, as mentioned. The 2 second bases for the reconsideration motion have to do with this idea that the damages award is absurd. It's not tied to any underlying harm. And according to White Castle, there needs to be some sort of reasonable association between the damages award and the underlying harm. And here, the argument is, what is the underlying harm? And I think that's an issue that all kind of defendants raise in privacy litigation. We're always asking ourselves, what is the harm? We challenge it on what's known as Article 3 motions. But to the extent there is a harm when the collection of your biometric information is done without your consent, how are we really valuing that harm? And is $17 billion the right amount? Another thing to mention is that Rogers, the BIPA trial, they've also filed a motion to amend the judgment there because the $228 million, according to the plaintiffs in the Rogers decision, is too low. The trial court there only used a one-time accrual, and under the new White Castle decision, according to the Rogers plaintiffs, they're entitled to multiple accruals per plaintiff. So both of these cases are subject to reconsideration, motions to amend, et cetera. So we might be seeing some modifications in them. But the main takeaway, again, is that the risks associated with the collection of biometric data in Illinois is quite enormous. And when we talk about things like business bankruptcies and business, just making it untenable for businesses to do and operate in Illinois, that's a very real concern amongst, sort of the defense bar.
I think it's important to note that Illinois is the only biometric statute that has a private cause of action. And so where you're seeing all of these lawsuits by plaintiffs, there's no other state out there yet. Hopefully there isn't one that we later see that has a private cause of action. So I think this is a little unique, at least in Illinois.
So Melissa, we have a question, and to that end, the question is, how does a decision in one state reflect on another state? So in the United States, at the state court level, this decision would not impact how other states view the collection of biometric information for two reasons. First, as Melissa mentioned, there really is no other state in the United States that has a statute similar to BIPA in both its statutory damage and private right of action amount. And secondarily, the jurisdiction of state courts are limited to the boundaries of that state. So these are all state court decisions. Sometimes when we're talking about federal courts in a state, those court decisions may be persuasive on federal courts in other states, but that would not occur here. This is very much unique to Illinois.
So speaking of biometric activity outside of Illinois, and I live in Chicago, and it's a little embarrassing that, we have this statute that doesn't require anything except really failure to sign a piece of paper that allows for massive type rulings. But in Texas has the capture or use of biometric identifier, similar to Illinois, provides protections for the capture and collection and use of these type of identifiers. It also, similar to Illinois, it does have certain restrictions around the retention and destruction. And so you have to destroy the biometric data within a reasonable time, but not later than a year after the purpose for collecting it is expired. So, and there are some exclusions to that, but if you have an employee and they're terminated, then it needs to be destroyed within that year. It does require notice and consent, but unlike Illinois, it doesn't have a specific requirement that the notice and consent be in writing. And then also, similar to Illinois, can't sell, lease, or otherwise disclose the biometric information unless, again, subject to certain exceptions. And the enforcement, like we mentioned, Texas does not have a private cause of action. Enforcement is by the Attorney General, and violators are subject to a civil penalty of not more than $25,000 for each violation, which, when you put it in context of what Mariah just said about how you can consider the rulings that have taken place in other states, although they're not controlling, that could make for a quite large finding against an organization.
And Melissa, I just wanted to jump in really quickly. We're getting a lot of questions around how damages are estimated in both Pixel and biometric space. And again, the general response to that is you need to go back to the underlying statutes. The reason plaintiffs are bringing these lawsuits under, for example, the VPPA or the state wiretapping or Illinois BIPA is because these statutes have what are known as statutory damages. They tend to range from $1,000 per violation to up to $5,000 for willful violations. And judges and courts tend to leverage those statutory damages in their damages calculations. We also see in settlement negotiations with plaintiffs that plaintiffs bar will use the statutory damages amount as a sort of formula, if you will. They'll negotiate downwards in the context of a settlement, but that's certainly their initial ask.
So going back to the Texas enforcement actions, there's two large ones that have really been we're watching with a great deal of interest. And interestingly enough, both of these cases are currently pending, and there are significant disputes over discovery. So we anticipate this will continue for a while. But essentially, Google has a lot of different apps out there. They have the photo app, Assistant Nest hardware. A lot of these capture different types of facial images or other type biometric information. And the Texas Attorney General said that they unlawfully collected and didn't obtain the proper consent to do so for Texas residents. And then also versus Meta, same thing with respect to the collection of facial geometry and biometric information without obtaining the proper consent for that information as well. Interestingly enough, there's been prior decisions that talk about collection of biometric information, where, for instance, here, these ones are all about Texas residents. And so if you guys are familiar with the Texas data breach statute, that one says that you have to notify even if your particular state didn't have a data breach statute. So here, it looks like they are limiting the information or the regulatory actually just for Texas residents. So I think there are some limits to what they're doing. There's another prior open records decision that was a while ago that says that the right for protection of biometric information stops after death. So there are some other things that are going to play into these types of resolutions with the Texas biometric enforcement actions.
And Melissa, here's a quick question that pertains to data breach. The question is, how does the analysis of harm work with regard to reporting a data breach? So if we are to report these disclosures as an impermissible disclosure, is that somehow a get out of jail free card?
No, it's the collection and consent. So in Illinois, you don't need to have an unauthorized disclosure or unauthorized use of the information in order to file a cause of action under the BIPA statute. It's simply not collecting it following the parameters and the requirements of the statute. Similar with Texas, it doesn't require an unauthorized use or disclosure. What they're looking at is this unauthorized collection of the information without having the appropriate notice and consent. And then regarding, there's another question on here regarding BIPA. If a patient needs to provide a biometric scan to enter a medical facility for treatment, would that be covered by HIPAA? And yes, because it would be a patient identifier. So it would allow you to identify the patient. We see this often in the context of cosmetic surgery, where the cosmetic surgeon has done some sort of nose job and posts the information about the surgery before and after pictures online. And that's considered biometric information and a breach under HIPAA, because if they didn't have the appropriate consent to release the information, they shouldn't have done so. So yes, that information would be protected under HIPAA. Also, what we're seeing is the FTC recently released a policy, May 18th, so very recently released a policy about biometric information. What I find really interesting about this, you know, I'm Irish Italian, and so even though you probably can't see it, I'm really using my hands. I can't help but talk with my hands. But in here, they have defined biometric information to also be characteristic movements or gestures, such as a gait or a typing pattern, etc., as biometric information. This is a very, very broad definition. I think, at least without having guidelines, I think there's going to have to be some parameters around what that means, whether it's distinctive or not. I frankly am not aware, wasn't aware that everybody has a typing pattern that would specifically identify you. I don't know, Mariah, if you're aware of something like that. So I found this definition very broad and very interesting, but it does signal the FTC's increased intention on this particular area.
So two thoughts. The first is keyloggers are another form of tracking technologies that have been subject to these types of privacy litigation. I don't believe in the context of your characteristics of typing, but certainly just logging keystrokes is another way that businesses have gotten in trouble. And then I also just wanted to mention that the FTC is also undergoing its first round of rulemaking in about 10 or 15 years, and that is geared towards commercial surveillance. So we expect some initial proposed rulemaking from the FTC in the commercial surveillance space, I think by the end of the year. Next slide. All right, so we're just going to cruise through this at a very high level, but the idea is that obviously with the emergence of artificial intelligence tools and technologies, we're seeing a similar kind of uptick in litigation concerning AI technologies. AI lawsuits are here. First and foremost, chatbots, virtual assistants. I mean, those are fundamentally AI-driven technologies, and we've already seen SEPA, wiretapping, et cetera, lawsuits being brought against them. The second kind of realm of AI lawsuits are going to be lawsuits that pertain to whether or not an AI technology, including, for example, generative AI technologies that scan and sort of gather lots of information from online resources, are violating copyrights and IP. For example, there's a big GitHub litigation in the context of OpenAI that we're following and monitoring, but there's been other allegations of copyright infringement by use of AI technologies. More interestingly, in my opinion, is going to be, and we've already started to see, lawsuits pertaining to the use of personal information collected for one purpose, used to make decisions of legal importance concerning individuals. So for example, one of the large sort of class actions that was filed in December of last year is Husky versus State Farm, the insurer. And the allegation there is that Husky was a policyholder. She had a homeowner's insurance policy. She submitted a claim, and State Farm utilizes a claims processing tool that essentially leveraged a lot of historical claims data, personal information pertaining to claims, and leverage that data for purposes of identifying claims that maybe had a higher risk of fraud, identified claims that potentially had some basis for denial. That Husky herself is an African-American woman who is subject to the use of this tool and technology, and that ultimately the tool has a higher denial rate when it comes to Black and African-American homeowners submitting homeowner insurance claims than it does against white and Caucasian policyholders. So very interesting case. It was alleged a violation of under our Federal Fair Housing Act. But again, the idea is if you are an organization that's using AI tools and technologies to process personal information and to make decisions on people, you need to look both at whether you have the proper consent and authorization in place to do so. And then you need to really be evaluating whether your use of these tools can lead to what's known as disparate impact or kind of unintentional bias, fundamentally discrimination. A lot of our state and federal regulators are concerned with the use of AI tools leading to discrimination in the employment realm. So we're talking about HR tech, we're talking about sorting candidates for job applications, sorting candidates or employees for promotion, et cetera. There's a lot of efficiencies to be gained by using these tools and technologies, but there's a lot of risks associated with them as well. Next slide, please. All right. So some other areas of focus for privacy litigation in 2023, geolocation information. To the extent an insured is collecting precise geolocation data, that really is kryptonite in the eyes of regulators, in the eyes of plaintiffs' counsel. That's the type of information that essentially can show movements at a very granular level. The FTC has gotten involved in a enforcement action against Kochava, which is a data aggregator. We've seen some recent settlements with state attorney generals concerning the use of precise geolocation data. And we have seen, of course, litigation filings concerning this information. Social media addiction is another area that there has been an uptick in filings. The idea here is that products, apps in particular, are defectively designed to increase users, to increase and kind of force addiction on these platforms and these technologies. So plaintiffs are bringing large class actions saying various functionalities of your platform are defectively designed, and they're used for purposes of making this class of individuals. They tend to be children, vulnerable populations, addicted to the social media platforms, and then of course reproductive health post-obs. All right. So generally speaking, how can we underwrite these risks? In general, pixel claims generally are not widely covered under existing cyber policies. They don't necessarily trigger coverage either where the coverage requires a breach. Again, some of this will turn on how the lawsuit is brought and the allegations included in the complaint. So if we're talking about an impermissible disclosure, that might constitute a breach. Whereas if we're just talking about wrongful collection, to Melissa's earlier point, wrongful collection is different than wrongful disclosure. So a lot of this will depend on how a complaint or how a regulatory investigation is sort of the terminology that's being used. Historically, we did see wrongful collection exclusions that might come into play. And there's other exclusions such as for unfair and deceptive trade practices that could also apply. And again, we're going to see an uptick, a continued uptick in allegations that cookie consent and the sort of disclosure of information to third parties is an unfair business practice. So we anticipate that we'll be seeing a lot of those exclusions potentially come into place. And then, of course, when we have those exclusions, there's still exceptions to them, right? There might be the obligation to defend. There might be a supplement for indemnity that's relevant. So the policy language is obviously going to be key. So how bad is all of this anyway? And are there things that we can do? Yes, let's move on to the next slide, or next and last slide. There are steps to take to mitigate risk. You need to start asking insurers very specific questions concerning their online collection practices. All right, we need to evaluate access to consumer and individual data via the use of tracking technologies. It has been roughly 1 year to 18 months. There is now an awareness amongst most organizations that online tracking technologies have various legal and reputational risks associated with them. And many businesses have taken a close look at their websites, and they have audited their websites to understand exactly what's going on, what cookies are being dropped. I cannot tell you how many times a business is sort of under one impression, oh, we only have X, Y, and Z cookies, and we're using them for these specific marketing campaigns. And then when they leverage some of these online tools, or they leverage a third party to actually do an audit of the website, they're looking at cookies, in excess of 3 times the amount that they initially thought. So there needs to be that initial audit of the website to really understand what's occurring there. And then we need to also be looking at privacy policies and evaluating whether what we say in our privacy policy is accurate to what we're actually doing on our website and on our online app and other digital assets.
Let me pause
please.
right there too. I think even, when you go visit an organization's website, sometimes you'll see they have a privacy policy. Sometimes you'll see they don't have a privacy policy. Sometimes you see that the privacy policy hasn't been updated since 2010. You can learn a lot of information about an organization simply by visiting its website and looking at its privacy policy before you even ask questions about them.
So there's a question, is the move to solve the cookie problem in data tracking with a cookie manager, which asks the user to opt in or opt out of consent? Yes, this goes to the last point. Consent mechanisms are fundamentally going to be key. However, plaintiffs will still bring lawsuits arguing around the enforceability of these consent measures. So for example, just because a business has a cookie banner, a cookie pop-up, just because they ask for affirmative opt-in consent, which is going to be the gold standard. It's not required in the United States as it is in Europe. But if they determine to ask for affirmative opt-in consent, that's the strongest and probably most enforceable model. But in the United States, sometimes businesses will just have the cookie consent banner and say your use and interaction of the site is subject to these terms and conditions. So that's just sort of a disclaimer. It doesn't require any type of opt-in or opt-out consent. And in other businesses might take the approach of allowing and having clear and conspicuous opt-out options, but the default is to opt-in. So depending on your cookie consent management protocol, the banners you use, and the type of consent you're collecting, that will allow you to have sort of stronger consent defenses to these types of claims. All right. Oh, another thing to mention is class action waivers and arbitration provisions in privacy policies are increasingly important. We have seen courts kind of reject efforts to move to compel arbitration of consumer class action claims. However, there has been some relatively recent Supreme Court decisions regarding sort of interpretation of arbitration provisions. So another thing we're going to look at when we're auditing our privacy policies is we're going to look at whether or not we have those very clear, very defined class action waivers and arbitration provisions. We give notice of them to consumers who come onto our site. We make them prominent in our privacy policy, and we have a good basis to assert that a consumer class action is going to be subject to either the waiver or to our individual arbitration. That can be very protective. That can be a very strong basis to also engage in a negotiation with a plaintiff's counsel for an individual and not class-wide settlement. All right, I think we're at the top of the hour.
So yes, thank you very much, Mariah and Melissa. That was a fantastic presentation, lots of information. We have recorded the session, so we will send, once it's been all approved, we will send all attendees a link, and also the presentation slides will be circulated, which will include Mariah and Melissa's contact details if anyone would like to contact them directly. So again, thank you both very much. That was such an interesting presentation and a fantastic overview of the landscape. I've learned an awful lot. So thank you very, very much.
Thank
Thank
you.
you.
Thanks for the opportunity.
Bye.
Bye-bye.